This meeting is
Good
being
morning. Good morning, everyone. This is Allison Scarborough, Consolidated Planning Group. We are here with the Down Syndrome Association today, attorney Mike Day and Mary Ann Hughes. And so the topic that we are talking about today is divorce and special needs. And so I just wanted to start out by introducing myself. If you're new to us, Consolidated Planning Group is a holistic special needs financial planning firm. We do webinars all the time on topics surrounding planning for special needs, everything that you can imagine, from special needs trust and guardianship, SSI, Medicaid, and just a kind of a litany of other topics. But today, this is a topic that we really only do a few times a year. So you're here for a reason, and you're here probably because you're probably at a point at a crossroads in a stressful time in your life. And I know from my perspective and from Mary Ann's perspective, we can tell you that sometimes when you think that you're in a tunnel and that you can't see the light of day, the smoke does clear and it does get better. But having a plan and working your plan and kind of learning some of the things that we're going to go over with you today is going to be important in your journey. From a special needs planning perspective, we are nationally certified as Social Security advisors and members of the Special Needs Planning Academy. And when it comes to divorce and planning for special needs, there are a few key things that I always like to, advise our clients that it's really, really important in your considerations. First things first that I like to talk about, I think that the topic of child support, whether or not child support is going to continue post age 18 for your special needs loved one, is an important topic to address. And I know Mike's going to talk some about that. Another thing that we like to talk about is where that child support is going. A lot of our kids don't qualify for SSI and Medicaid as minors because as parents, we just make too much money. But when they turn 18, it's based off of their assets and income, not ours. So where that child support goes really, really matters. And I know that Mike is going to mention that as well. So that's a topic that we like to remind people of. And then the last thing that we like to remind people of is that it is important to have the discussion of life insurance on both parents to basically fund a special needs trust for your loved one in the future. Whoever the parent is that ends up paying child support, if something happens to that parent and they pass away, that child support ends. That's all there is to it. So that funding for your loved one and their future care is really, really important, and life insurance is a big consideration in that. So for today, let's talk about some housekeeping items really quick. We are in webinar mode, so we can't see you or hear you, but we do know you're there, and we are glad you're here and you're in the right place. We do want to take as many questions as possible today. So if you have questions throughout the presentation, I'm going to be monitoring the chat box, and I will read those out to both Mary Ann and Mike. So you can just put those in the chat box. Today's webinar is being recorded, and everybody who registered is going to get a copy of today's slides. So you don't have to write everything down feverishly to make sure you get it all down. You are going to get a copy of today's slides as well. So we're excited to have Mary Ann Hughes with us today. She is a coach when it comes to divorce, and she's kind of the boss on this. She's really, really good at what she does. She's got a lot of skills. So Mary Ann, welcome. Thank you for being here. Mike is an attorney and works with special needs divorce. And one thing I want to mention is, our families, special needs families, we have connections with attorneys. We may have worked with an attorney in the past for a special needs trust or for a guardianship, and those are different attorneys. Those attorneys typically don't do divorce, and the divorce attorneys don't typically do the special needs side of the house. So Mike's going to talk a little bit about that today. So you guys are in for a treat. We're going from 11 to 12. We will be done by 12 if you're planning kids and activities for today. So Mary Ann, thank you for being with us. Tell us a little bit about you.
Thank you so much, Allison. Pleasure to be here and to share my story and my advice to all of you to get through divorce involving children with any kind of disability. It can be very challenging, but know that it is possible to get through it and get through it well with the right supports and people in place. And so I'm a certified divorce coach. My company is Special Family Transitions, and please reach out if I can help you anytime. So if you're in this session, you're probably either thinking about divorce or facing it, and it can be a crazy, overwhelming time. But know that with the right approach, you can get a good result for your family. Okay. And so just a little bit about me. I'm a mom of 2 boys on the autism spectrum. And this is a picture of me taken with them when I was newly separated. And so know that may be challenging to go through, but there is light at the end of the tunnel, as Allison mentioned. And so when I faced divorce, I spent a lot of time, money, and energy trying to figure out how to get through the process and how to get a good result for my family. And glad to say that I did get there, but it was a long, hard road, spent a lot of money, which I don't want anybody else to have to do. So I decided to help others navigate the overwhelming complexities of divorce by sharing my knowledge and helping them through their process as well. And so I'm here to provide, so I started my company, I guess, after my divorce, so I could help with divorce coaching, consulting, and support. I was excited to participate in it's called Lone Star Lend, and a program you have heard about, and if is one I recommend participating in if you have the opportunity to. But it taught me a lot of things, and there was a service learning project, and I chose to do one on supporting neurodiverse kids in divorce. So with a team, we got some the top psychologists in town to participate. And so there's webinars you can find on YouTube at Lend Divorce Project to kind of give you some ideas as to how to support your kids through the process as well. Because as a parent, it's hard enough, but for the kids, we have to know how to support them so that they're in a good place through the process and beyond as well. And so as a life coach, divorce specialist, and coach, I'm here to help you. And one way I do that as well, for those maybe who can't work directly with me, is I just launched my first digital course I'm excited about, kind of condensing my knowledge into 1-hour session. And so please reach out to me if I can help you in any of those areas. And so trying to figure out how to condense all my knowledge into 1 hour, into a framework that would help support people no matter where they are in the process, is I came up with a system called RISE. And so what I've done is each letter in RISE represents different things that you should do and can do as part of your divorce process to get the best result for yourself and for your family. And so I'll go through each one of those aspects. So the first R is for recognize and resolve. A lot of times when we first are faced with divorce, we just, feel like you got hit by a ton of bricks. And so part of it is getting in the right mindset to approach your divorce. Sometimes we're just so overwhelmed by emotion that we're not thinking clearly. And so recognize that we're in a situation that's very new and very different and can be very scary. And so what I realized going through it is that you're actually part of the grief cycle. You may have heard of that in different contexts, but that basically comes into play anytime you're with a situation of loss or grief or change, whether it's someone dying, a new job, whatever it may be. And divorce is a big change and loss and big change happening in your life, that you go through different cycles and different phases. And so just recognizing that it's okay to be in denial, anger, bargaining, depression, but really we make the most progress when we finally get to acceptance and can find our way forward to get through the divorce and life beyond that. And so you got to resolve. Oh, go ahead.
Marianne, I just wanted to say, in these stages of grief, one thing that we know is that we really don't make a recommendation to make major financial decisions unless, of course, you have to as a result of big decisions to purchase something or things like that, or because a lot of times when you're in those stages of grief and you make those decisions, they usually end up being the wrong ones or ones that you regret later. So we really do, suggesting that you just take time and really consider kind of where you are, and knowing that if you put off that big financial decision 6 months or a year, it's probably not going to be the end of the world, but you may regret it. So we do like to talk about that.
Okay, wonderful. That's great advice. And so, yeah, you just go out there and resolve to get the best outcome you can and to meet your goals for divorce. And so I is for identify and investigate. And this is where people like Allison come in to help you identify what you have and what you need financially in terms of your assets and what you need to do in the future to address your child's current and future needs, and trying to figure out what those are. So you've got to investigate services or programs your child may need in the short and long term. If your child is young, maybe you haven't even started thinking about this, but this is the time to at least figure out what you're dealing with now, maybe the current therapies that they do have and need or will need in the short term, as well as things that you can envision for when they maybe age out of school. And it's hard, like I said, to get to think in those terms, but Allison can definitely help in that area, as well as other people who can help you kind of think in terms of a life care plan. So this is not like a one and done, get divorced, but the assets kind of situation with a special needs child. You've got to think in the long term and how to agree to things on your divorce, whether it's child support, whether it's how you're going to continue to support the children in a way that makes sense for what your family's needs are.
This is where future care cost estimates come in to play as well. And you mentioned therapy and things like that. The needs of the child. Some of our kids stay in high school, past age 18. There might be a transition program, various day programs or things like that, maybe there's attendance services and things like that. This is where those future care cost estimates come into play when we're looking at the whole big picture.
And then S is for self-care support, securing your team, and special needs. And so as special needs parent, we often put our needs last, but this is not the time to do that. You've got to take care of yourself. As they say, you can't pour from an empty cup. So if you're there in the best condition you can be, considering everything going on, to be able to think clearly and make better decisions in your divorce, be there for your kids, support them, then everyone's much better off. And so you can't do this alone. So seek support if you can from those that have either been through it or there to support you, family, friends, professionals, and different groups like the one you're in now may have some resources to help you as well. And then find professionals who can understand the special needs considerations and help you advocate and also protect your child's needs. There's a lot of people out there who maybe are professionals but don't have special needs experience. And this is not the time to you want to get it right, I guess. Going into this is your one shot to on the front end, make sure you find the right people and do the right things in your divorce. And Michael will talk about this later, to make sure that the decree is set up in such a way that you're protecting yourself and your children for the future. And so you can always come back later, but that's going to cost more time and money and stress in the future. So definitely find people, whether it's family law professionals, special needs financial planners, divorce coaches, whatever it might be, that have understanding of the special needs and what needs to go into that.
I think it's important to note that all attorneys are not created equally. They all go to law school and they pass the bar and things like that, but they are not all created equally. And I kind of liken this to our situation is specialized. So just like if you had a heart condition, you're not going to go to your PCP. You're not going to go to the podiatrist. You're going to go see a cardiologist. You really, if you're going through this, or you find yourself, maybe you might go through this, you really do want to consult an attorney that does have background and understanding of special needs and kind of what happens in divorce with special needs and what should happen. So I always like to talk about this here. What if you've already hired an attorney and you've already dropped a huge amount of money for a retainer, because it's a lot of money, right? It's not ball it all up, throw it away, fire your attorney. That is not what we're suggesting, but there are people that you can pull onto your team. So you hired your attorney because you liked your attorney, and maybe your attorney doesn't have any background in special needs, but there's truly a way that you can connect with people like Mike, are other professionals that are nuanced and special needs, and they can come in from a consulting perspective. So we do like to mention that because that kind of comes up sometimes in the event that you've already hired an attorney. And Mike and I were talking about this a little bit earlier. We think that it's best, and it doesn't always work this way. So having said that, we do think it's best to get things right on the front end. Okay, get things set up right on the front end in the decree, the child support, all those types of things, because going back to the judge later is costly. Everybody has to hire an attorney again. It takes time. There's emotions involved with that. And so there may be some people on here that have gone through a divorce and it wasn't set up right, and now you're here because you want to learn more or whatever. All is not lost. It can be fixed. It's just easier to get it right on the front end. Don't you agree with that, Mike? Talk to us a little bit about that.
Yeah, I absolutely agree with that. I mean, there are a lot of nuances to these cases, both on a child support perspective, but also in other respects. I mean, a lot of people don't realize that the adult disabled child statute also governs possession and access for after the child is 18, which is highly unusual in Texas family law. And so it's very important to remember that it's not just about child support, but it's also about possession and access. And I can't speak for all jurisdictions in Texas, but I can speak to Harris County in particular, that, if you have a guardianship, that's going to be in probate court. Well, those judges, they're wonderful judges, but they don't like to really, if they can avoid it, they don't really want to get involved in family law matters in the context of a guardianship. They really want the family courts to resolve things like child support and possession and access, and potentially, and I don't want to get too much into the weeds, but there are potentially other issues that could come into play as well. And the other thing I'll say is that Allison's absolutely right. You need to get a legal professional who's knowledgeable about children with special needs and the legal nuances there. But that's not true just on the family law side, because what folks like I do is I want to get an estate planning attorney that is highly knowledgeable about preparing a special needs trust, okay? Because, for example, child support, it's got to go into a very specialized type of trust called a first party Medicaid payback trust. That I would be reluctant to let just a run of the mill estate planning attorney draft one of those. I would be reluctant to say, oh yeah, this estate planning attorney is board certified in estate planning. I wouldn't even do that. I mean, in a place as big and diverse as Houston, there are maybe like a dozen lawyers who I would feel comfortable drafting a special needs trust. And then if you are somewhere outside of a major city, I would be very much inclined to really invest, because you don't have to hire an estate planning lawyer from your particular town or what have you. You can get somebody from somewhere else. There are great lawyers in Dallas, great lawyers in Austin, great lawyers in San Antonio, but don't feel like you have to use somebody local on the estate planning side. And if you're a family law attorney, they just have to be mindful of the estate planning considerations. They really do. They have to work backwards from that.
Mike, we make referrals all across the state of Texas for estate planning attorneys that are nuanced and special needs. And like you, we say, hey, again, this is specialized, so you want to work with an attorney that is specialized in this. We have actually seen documents that were drafted that failed to qualify as a special needs trust in the eyes of the Social Security Administration because your neighbor next door, the real estate attorney, did it for you for free, or your brother or whatever. And so in fact, we have, a lot of attorney clients. They're very, very smart, but we've referred them to estate planning special needs attorneys because they have a special needs, child. So I think that is really, really an important consideration. But you mentioned something, Mike, before we go back to Mary Ann, about guardianship. And I just was curious about that because, some families do know they definitively have a child that is going to require guardianship. A lot of families don't know. They're hopeful and optimistic, but their child might not be there yet at 18, and it's kind of on the fence on whether or not a full guardianship is going to be needed. Is there language that can be put into a divorce decree on an agreement that the guardianship will be set up in the future, or that, the parties agree to a guardianship in the future, or some? Does anybody do anything like that, or is that something that can be done? if
Uh,
that's the case for this child?
so a couple of thoughts. First is that if you have a child who's going to be considered an adult disabled child under the child support statute, and we can get into the specifics of that, but generally speaking, that's a child who's incapable of self-support because of a disability that was known prior to the child turning 18. A lot of times that will naturally feed into the guardianship proceeding. Um, it is rare to put in language in the divorce decree about the guardianship per se. I would say as a general proposition, you might be able to. Is it binding on the probate court? Probably not. But does it give you a little bit of insurance? Yeah, maybe. And I've had cases in the past involving children with special needs where you actually have parallel litigation going on in the probate court and in the family court. And sometimes you need something to happen in the family court to where it may not be binding per se on the probate court, but it will telegraph to them something that's very important. For example, I was working on a case. There was an adult disabled child. The father didn't want to pay child support anymore. And he did some things that were just really wrong. And I'll just leave it at that. But there was ultimately a finding for attorney's fees made against him to where he had to pay the attorney's fees into the obligee's trust, right? And so, but the reason, and the other side was like, look, uncle, we give up. We'll non-suit it. Just leave us alone. Why are you asking for attorney's fees? Well, the reason why getting attorney's fees in that case was so important is because that father was going to try to pull something in probate court because he was not successful in family court. And so it's one thing if the probate judge says, oh, well, father dismissed it. Okay, fine. As opposed to the court and the family court judge making these findings that dad did something wrong and had to pay attorney's fees. Well, that's going to send a completely different message to the probate court. And so when you have parallel litigation, you should always be mindful of the fact that you're going to have multiple audiences.
One thing, Mike, that you just said, and this is something that is, all is fair is love in love and divorce. But when there's child custody involved, whether it's special needs or not, emotions run high, and there's no right or wrong party as far as mom or dad or who's better, or whatever. But one of the things that I think I do want to mention is that judges are pretty hip to false accusations that are involving CPS. That is like an old trick in the book as far as child custody is concerned, and it doesn't ever go well for the person that makes those false accusations. Not that anybody is planning on doing that. Maybe you've had false accusations made against you. Those are, all things that could happen in the divorce, but it just kind of makes the whole situation that's already difficult a little bit worse. So, for sure. So, yeah. Marianne, tell us about your S.
Yeah, so the last S is special needs considerations, but I think Mike's going to talk about most of these, and some of these we've already talked about slightly, so I'm going to skip over this slide for now. But feel free to put in the chat as anything else you want to talk about specifically when we get through all this. So once again, these are things that are financially, legally related, but know that there's different things to consider and different ways to structure so that your needs and the child's needs can be met.
One thing on here, Marianne, I want to comment on. So, and we mentioned this earlier, and I know Mike's going to talk more about it, that, it's real important that child support is redirected for the special needs child that is going to basically qualify for SSI and Medicaid in the future. If child support is continuing post age 18, for that child support to go into a first party special needs trust. On the screen here, we have an ABLE account 529A. And that is for an individual with a disability whose disability started prior to age 26. We have entire webinars on 529A accounts. But I just wanted to bring that up because I have recently been asked several times in the last month, somebody is putting out bad information that you can have child support directed to a 529A ABLE, and that is not true. And so I want to dispel that myth. If you get child support, you could go and put it into a 529 later if you want to, that's fine. But child support does not get directed to a 529 ABLE. And child support that is received and then put in a 529 ABLE is still going to be counted as income for SSI purposes. So the only way for child support not to count against the child for SSI and Medicaid purposes is that it is redirected to a first party special needs trust. So I wanted to just kind of quash that myth, because it is a big myth and it is going around a lot lately. So I just wanted to make that clear.
Those are all great points. And this is why it's so important to work with someone like Allison, like Mike, and people who really understand all the nuances, intricacies of what needs to happen in a special needs divorce during and after.
Yeah,
So,
I just want to add one thought to that. Allison's absolutely right about that, but it's not just about child support, right? Because it can, I mean, to a certain extent, divorce or even post-divorce management of child support is estate planning by other means, right? And so one of the reasons why you would want to get a really good estate planning attorney involved is because you might have multiple trusts, right? You might have a trust that receives the child support, but you might have another trust set up, and maybe you have, a child who has special needs, and then you have a child who has different needs, but maybe they're not special needs, or it's all to a different extent or different situation, what have you. And maybe you don't want everything going to the federal government, right? And so there's that consideration as well, because, and we'll get to this later, but the law gives people the ability to be more creative than maybe they could have been 5 years ago.
Great points. And so my last E is how you express yourself, execute what you have to do, and embrace the change. So as Allison mentioned, emotions run very high. And so we want to be careful, though, that the way we express ourselves is not run by our emotion, but more by our logical side. And so that's why as a coach, that's what I help you do, is get from the emotion to the business of divorce in a hopefully more logical fashion. And so there's a system of communicating called BIF, in case you've heard of that, which stands for brief, informative, friendly, and firm. And so you want to try to express yourself in that way throughout your legal process, not just to your attorneys and people you work with, but also with your soon-to-be ex-spouse. And this also applies after the divorce as well, as you're co-parenting. So that way, just focus on the kids and what you need to do for the business at hand, as opposed to focusing on the past, the hurts, and just try to, as much as you can through this process, take that out of it, or else you'll find it's going to spiral if you just focus on the emotion and trying to get revenge or whatever your motives might be. So just focus on getting the best result for you and for your kids, and treat it kind of like you would like a business deal, even though it sounds a little bit harsh and cold to say, but in the end of the day, the divorce is a legal and financial transaction, and that's what we've got to deal with. And all the emotions, that's what other people can help you with, coaches, therapists, and so on. And then
when they go unchecked, those emotions, when they're going unchecked, what it equates to you is dollars and cents out of your pocket. It's more expensive. It's good for attorneys. No offense, Mike. It's good for attorneys. The more you fight, the more you argue, the more you don't get along. Some people don't have a choice. Some people's situations are really, really bad, and there is no choice. And I recognize this, but at the end of the day, if we can focus on our kids and what matters the most and the best interest of our kids, because that's what the judge's focus is the best interest of your kid, that is going to be the best. And it's going to keep your expenses lower, which you can spend more on their college or other things. You can spend as much as you want in attorney fees and going to court and having hearings and all of these other things. But at the end of the day, the law is the law. And if you can come to some sort of good arrangement without, with avoiding those big hearings and things like that, it's going to be much better financially in the long run. Mike, what would you like to say about that?
Well, I would just say that is absolutely true. I had a client who was going through a divorce once, and it was a very amicable divorce. In some respects, but in some respects it absolutely was not. But she shared with me some knowledge that she had gleaned elsewhere that I thought was really, really good, and I've kind of shared with other folks, which is that be nice about everything but the money, because that's exactly right. And when you're sending these text messages, just be mindful of the fact that, again, multiple audiences. It's not just your spouse or soon to be ex-spouse. It's also a judge. It's also a jury. It's also the other side's lawyer, mediator. I mean, all these folks who could have a real impact on your future. And don't shoot yourself in the foot, right? Just be mindful of the fact that if you're going to send something that maybe you shouldn't have, or maybe you should have slept on it, right? That other audiences will see that. And I was also was trying to find it, but I'll maybe we'll figure out a way to get it up to any audience member. But I read an excellent book by this Canadian psychotherapist who's very prominent in the Canadian family law world. And he talks about how when people are going through a divorce and they're very upset, a lot of things are happening at the same time. But one of the things that's happening is that someone is potentially going through a massive disillusionment, right? Like something just didn't work out. And a lot of times that will dovetail with disillusionment that had happened in some other arena of that person's life. So it might have been their upbringing, their parents went through a divorce, and the only way to really kind of address that is to really know about it, right? And a lot of times what this psychotherapist saw and what I've seen in my practice from time to time is that there is some sort of disillusionment that's going on that people cannot process. And cortisol brain is very real. You take something that's inherently very stressful, and then you have this background noise that's going on in your head, and you may not even know that it's there, right? I was watching a really great Brene Brown podcast the other day, and she's talking about, well, people don't want to get in, open up Pandora's box. Well, guess what? Whether or not you want to open it or not, you're already there. And that's especially true in a divorce. And so I just wanted to pass that sort of tidbit on.
And then, so commenting on what you said earlier, the long and the short of it, summing that up, is anything you say and do on social media or text message or email or Facebook can and will be used against you in court if you're going in front of a judge. So just be mindful of that before you press go on anything like that. Those are things that, we hope that it doesn't come to that in your situation, but it's just really important. Don't say or do anything that you don't want in front of a whole courtroom.
That's right.
For sure. Can we go back a step here?
Yes. Is it showing on your end, Marianne?
Yeah, I see it now. Yeah. And so, all this can sound overwhelming and it's a lot to process, but just break it down one step at a time. You'll get through it and engage people who can help to get you there. And like we said, it's, there's a lot going on. There's a lot to consider. There's all different aspects. Divorce is hard enough anyway, but no, you'll get through this. And so the last E I want to touch upon is that divorce can be scary. It can, it's not something maybe you anticipated or wanted, but know that once you go through it, it takes a while to process part of the grief cycle and everything else, but just embrace the wonderful opportunities that will await you once this is complete. They say it takes 3 years to fully get past the divorce and everything that that will happen to you as a result of that. But know that the future is bright. There's so much there for you and for your children. And look at this not as an end, but as a new beginning. Look at me. I was stay-at-home mom for over 20 years, taking care of my kids. And so through this experience, I've grown and developed and now have my own business for the first time. And I'm making an impact to the community. So know that this is a start for something that can be positive in your life. So don't look at it as, like Mike mentioned, be nice about everything except the money. There's a lot to consider, but know what you stand for and take all the information you get from all your planners, all your help to state your case about this is the money that where you want to make a decision and everything else related to that, whether it's possession, whether it's other things in the divorce. There's so many different aspects, but know that balance everything so that in the end, it's going to work out for you and for your child. And there's hope.
Some of that balance, Marianne, comes to what's it worth too. Because, you mentioned, and I know, from my perspective that, things can be drawn out for 3 years. And if you're just starting this journey and you hear that, you're like, oh my gosh, I'm getting off this webinar right now. Because you can't even imagine just being in that a 3 year of whirlwind. The more fighting, the longer it takes. The less fighting, the shorter it takes. The less fighting, the cheaper it is. And so some of the things I think it's kind of balancing and thinking about, just like when you were saying, kind of evaluating and those types of things. What is it worth to you? What is it worth? And so if all of the fighting and antics goes on and it drags it on 3 years, and that's 3 years of stress instead of 1 year, some of those things that you just have to find balance in that, and nobody can tell you what the right answer is for you. But as the longer it is drawn out, the more stressful it is. It's just kind of that thing that's hanging over you for a long time, and a longer path to get to the light at the end of the tunnel, I guess I would say. So Marianne, thank you for sharing. So Marianne owns Special Family Transitions. She can help you on your journey. She's got a lot of knowledge, and her contact information is going to be here and on another slide as well. So you can reach out to Marianne directly and learn more about her services and how she might be a great member of your team as you're kind of going down this journey. Thank you, Marianne, for sharing what you have. I appreciate it. And I'm glad that you're doing what you're doing. There's not very many people that do what Marianne does. And so, or that has the background that she has with special needs. So I, for one, am really, really happy to be able to partner with you.
Thank you so much. Really appreciate it.
All right, so Mike, you are up. So we're going to get into the weeds a little bit on Texas. So anybody that is here from outside of Texas, Mike is predominantly talking about laws in the state of Texas as it relates to divorce. So Mike, tell us about this.
Sure, of course. Let me start off though on coming back to something y'all were just mentioning, which is, you don't want the divorce to last for 3 years. That sounds overwhelming. That is absolutely true. The one thing that you also want to be careful not to do is rush through it. Because, like, for example, in Texas, everything can be done within, once the divorce petition's been on file for 60 days, absent some pretty extraordinary circumstances, that's the shortest time that you have to wait before you can get a divorce. And so sometimes people will come and say, look, we've exchanged spreadsheets. We already know what everything's worth. We're ready to get the deal done. And the only thing that I'll say about that is that, and I've seen this happen a couple of times recently, is that there's a lot of financial knowledge that's already been distributed. However, someone was not emotionally ready to really conclude the matter. And so there was still a lot of unprocessed anger. And that meant that settlement negotiations were pretty much a waste of time. And so that's something else to be mindful of, is sometimes you want to kick the can down the road a little bit because you want people to be in a situation where they've processed their emotions. And, and unfortunately, both sides, well, certainly ideally, both sides do that some, right? Because 90% of cases settle. That does not mean, though, that there's not some heartache along the way. And that does not mean that once the 60 days has elapsed, people are ready to settle. People are ready to get to that 90% threshold. Because guess what? You may be there, but the person in the other room with their lawyer at mediation, if they're not there, then you're going to have some wasted time. Or maybe waste is the harsh term, but time that you could have spent that time more constructively doing something else. Let me put it that way. But let's talk about the slides here. And a lot of this dovetails on what Marianne has said, so we'll try and kind of get through it at a quick pace. But yes, self-care is essential. And somebody like Marianne is wonderful. I would say, therapists have a role. Marianne's not a therapist, right? She's a divorce coach. So she's not there necessarily to build the therapeutic alliance. She's there to, to borrow an expression that's become more popular, get stuff done, right? She's helping you be the best version of a client that you can be. because that is the thing about going through this process, in particular, if it's being litigated, is that whatever trauma happened during the marriage that resulted in where you are, that trauma necessarily is going to have to be revisited some, right? Because you're going to have the lawyer on the other side might ask you questions in a deposition or at a hearing, or maybe they'll do these things called interrogatories, which is a fancy way of saying, I'm asking you questions that you have to answer, right? You are going to have to relive that trauma. And cortisol brain is very real, and it's going to cause some heartache. And it's unfortunate, but there's not a whole lot that can be done about that. And so that's why you want to be in a situation to take care of yourself. We've talked about getting an interdisciplinary team. I think a divorce coach is excellent. I think you must have an estate planning attorney that is knowledgeable about special needs issues. And I would say that a financial advisor is essential as well, because your lawyer is not they might know a little bit about a lot of things, but they're not there to tell you how to structure your portfolio. They're not there to make sure that your trust is drafted correctly. That's not the purpose of a family law attorney. And if a family law attorney is telling you that they can do all of those things together, be careful.
Run. I think the key thing on this slide is special needs. And that's the thing, and we hit on that earlier. Your situation is specialized. Work with specialists that are nuanced and special needs, whether it's the attorney, the financial advisor, the divorce coach, the medical team. Like in Houston, Baylor has a transition, a really, really good medical team, transition team for special needs. So you don't want to work with a generalist in this situation, because your situation is not a generalized situation. And that, I think that's the key that we want to drive home, and so super important. And it's really super important whether you're going through a divorce or not. So whether you're working with a special needs planning attorney for your special needs trust or your guardianship or those other types of documents, or an advisor. For instance, people like us, there are 250,000 financial advisors in the U.S. and 150, not thousand total in the U.S. are nuanced and special needs. Okay. And so that means the bulk of the financial advisors all across the United States have no background at all of having money in the right buckets, are advising you accordingly, so that way to maintain the eligibility for your child for state and federally funded programs and those types of things. And that can be a big deal in the end. So that's why we talk about that. All right, so let's talk about an adult disabled child, Mike.
Yeah, so this is the statutory definition that is what you have to meet in order to be an adult disabled child. And that we're talking about having child support paid after 18 and graduating from high school. We're talking about possession and access issues after a child's turned 18. So the child, whether institutionalized or not, requires substantial care and personal supervision because of a mental or physical disability and will not be capable of self-support. And the disability exists, or the cause of the disability is known to exist on or before the 18th birthday of the child. So a lot of times people want to get these findings before the child turns 18 because of collateral consequences for governmental benefits. Each situation is different. I don't know that Texas law necessarily requires the finding before the child turns 18, but there could be collateral consequences if you don't get the finding before 18. If that makes sense.
So, Mike, I just have a question, because I bet that there's some people on here that may already be divorced, or they think that their settlement wasn't great, or what they ever had set up wasn't great. So what if I am already divorced and I didn't get child support extended post age 18 because I hired a generalist attorney and he didn't know to pursue that? Do I have any background to be able to go back, or how does that work? Just in case there's anybody on here that's in that situation.
I will give you a typical lawyer answer. It depends, right? Each situation is different. I will say that I would not say that all hope is lost. I wouldn't say that at all. But because each case is different, you and each court is different, right? Like, sometimes judges will have different opinions about things, and there's a lot in the family code and in family law in general as it relates to children with special needs that it's unsettled. It's unsettled, right? Justice Eva Guzman, who was she was one of the few former family court trial judges that has served on the Texas Supreme Court. There have basically only been two in the last 30 to 40 years. And she was one of them. And she wrote a very interesting, it wasn't quite an opinion because the Supreme Court didn't take up the case. But basically what she said is that this statute is very nuanced and there are a lot of gray areas. And that involved an adult disabled child who was going to college, right? And the father was like, I don't want to have to pay child support anymore. This kid's going to college and is ostensibly living in a dorm room. And why should I have to pay child support for a situation like that? And so that he didn't prevail at trial. The Intermediate Court of Appeals in Corpus Christi affirmed the trial court. And then that's when Eva Guzman kind of wrote her analysis saying, we're not going to take this case. We're not going to overturn this case, but this area of the law is very nuanced. Hopefully that answered your question, Allison.
Thank you.
And sometimes you won't know if the child's going to be able to meet that statute, right? It's too soon to tell. And so it can still be a factor for above guideline child support though, right? And that's still something. Cutting edge issues, Quadros and Secure Act. So Secure Act is federal law, and it said for the first time that you can use retirement to fund a special needs trust. Yeah, so and I won't speak a whole lot about this, just to say that the Secure Act is brand new, got passed in 2021, I want to say. So the special needs estate planning bar is still kind of figuring out what it means, what it lets people do and not do. So you could talk to a couple of different lawyers that are really good lawyers and get different answers. That's not because one of those lawyers doesn't know what they're doing. It's because this is brand new federal law. And the last time I looked at this was a month ago, but I am unaware of any state appellate opinions that have addressed the interrelationship between the Secure Act and the Adult Disabled Child Support Statute.
I think what they've said ever since the Secure Act has come out is it's been mostly gray. It's not as clear as mud. Yeah. There's a lot of language in there that it says one thing and then the other part says this, or it kind of just leaves you hanging on, okay, so what does that mean? And it's kind of left to interpretation. So if you have 10 attorneys that are nuanced and special needs, they all interpret it a little bit different. So we've been seeing that as well. Hopefully there'll be some clarifications on that soon.
Well, the one thing I want to add to that is that the Texas legislature recently changed the child support statute to allow quadros to support a judgment for past due child support. So if you're in one of those situations where maybe you had child support obligation past 18, maybe it's going into a trust, maybe it's not, but you're not sure how you can really collect that money, you can now get a 401k to collect. You can garnish retirement, which a lot of people thought you could do under ERISA. There's a case called Dalton that came out in 2018 that kind of called that into question, or basically prevented you from doing that in a manner of speaking. And so the legislature fixed that glitch in the last legislative session.
And that is better for people that are owed a considerable amount of money, because usually when you're owed a considerable amount of money and you go back into the court and you get a judgment, it's still piecemeal paid back. It's not usually a lump sum paid back. It's, over a period of months or years. So this would be an easier way to go about and get a lump sum payback from the retirement account. Okay, so determining, we got about 10 minutes left.
Okay.
Let's talk about determining child support and how the state looks at that. Okay,
so let's go to the next slide, and that will tell us the factors. And part of it depends on whether or not you are, so there are basically two general ways of looking at child support for an adult disabled child. The first thing that you have to look at is the specific statute. So this is the statutory criterion from the specific statute, and you guys can read that yourselves. But that is what you're looking at. So, and what's really important about this is any existing or future needs, right? And so that's the importance of getting a potential life care plan involved, right? Because it's almost like a personal injury case in the respect that you are showing your damages model, right? I mean, you're showing what money should be paid to take care of stuff in the future, and sometimes that is extremely expensive, right? And that's just something to be mindful of, and that's not something that all lawyers know about, I would say. And then the other thing is that you cannot just look to the adult disabled child statute, but you also have to look to the general provisions for children who are not with special needs. Okay. And basically, if the obligor is making above a certain threshold, which gets adjusted every so often, but it's effectively around $9,200 a month after taxes. If they're making more than that, then what you look at is the proven needs of the child, and you look at the two income streams from both parents, right? If the child support obligor, the party that's paying child support, makes below that threshold, well, then you look at like 20 different factors. But the long and the short of it is those 20 factors basically speak to the needs of the child, because that is the thing about child support. It is not about lifestyle. It's not about the lifestyle of the parent, and it's not about the lifestyle of the child. It's about the needs of the child.
So, Mike, there's a such thing as Marianne put in the chat box for me of above guideline child support for an individual with a disability. And this is where, in my experience, attorneys that are not nuanced in special needs divorce, they mess this up. So talk to us about above guideline child support in that case of an individual with a disability.
Well, so if the child has a disability, right, you look at these factors that we just went through. But if the obligor, well, you have to look to see how much the obligor makes, right? Because if the obligor makes above the cap, right, if they max out, then you have to look at the child's proven needs, right? So if you can figure out that the child's proven needs are, say, $4,000 a month, I'm just kind of pulling a number out, right? Then you look to both parents' resources, right, to get to how you're going to pay for that $4,000. And chances are the obligor is going to have to pay for all of it, although that doesn't have to happen, right? And there have been some interesting cases that have recently made the non-primary parent pay child support made the primary parent pay child support to the non-primary parent, for example. There have been a couple of appellate cases that have come out in the last 4 years that have said that. And so, but really what you're looking at is the child's proven needs. Then you're looking at the resources of both parents and how do you get to that $4,000 or $5,000, whatever the case may be. If the obligor makes below that threshold, then you look to those 20 factors. But again, long and the short of it is you're really looking at what the child needs. Great example for this, it would be private school tuition, right? Is that parent could say, well, my child's always gone to private school, so I want that tuition paid as a form of child support. Well, if there's not a need for private school, then you're not going to get that as child support. But there have been 1 or 2 cases where if you can really litigate that the child needs that private school, right? And the one case I'm thinking of was a child who was not a child with special needs, but certainly the rationale would apply, right? Is that you have to look to the needs of the child, right? And the statute specifically says existing or future needs. So if you have a child who's, say, 12 or 13, and they're on the spectrum and they need to go to a certain type of private school, and that's something that they need to do, then that gives you the opportunity to present the court with that. Did I answer your question, Allison? And I know we were running short on time. And
Sure.
And possession and access of the child, again, we're talking about, who gets to spend time with the child after the child is 18. It's as simple as that, And okay, so we've kind of gone through how the amount of support is determined, right? So we've kind of gone through that. The only
I
other-
have a question though that
Sure.
I'd like to ask. If the primary conservator is paying child support to the non-primary conservator prior to the child turning 18, will they have to continue after 18, even if they provide the majority of the care?
No, and in fact, I am unaware of a special needs case where the primary had to pay to the non-primary, right? Those cases did not involve children with primary. Those cases did not involve children with special needs, excuse me.
Got it.
I just want to make that clear. But again, each case is different, and courts do consider, or certainly are supposed to consider, when the impact of a parent providing care for the child with special needs.
So this dispute over whether a disability exists, yes, we've definitely heard of this, where one parent is saying that the child isn't really disabled or isn't that disabled or something along those lines. So how do they mitigate that if that's something that they're faced with, or how do we overcome that?
Well, if it's a close call, what I advise clients to do is look into getting an expert that will testify. And that can be difficult because that doesn't happen very often. Okay. And there are lots of reasons for that. But in effect, what you need is an expert who is knowledgeable about the child's underlying medical issues. I would be reluctant to get the treater of the child to offer an opinion. There's an argument to be made that a treater could offer that opinion. And frankly, it kind of deals with it. It kind of hinges on that medical provider's underlying discipline, right? Because like a treating psychologist is going to be especially reluctant to do that. But if you have somebody else who is not a psychologist, maybe they're a doctor, right? It just kind of all depends. And this is interesting because a little while ago, I was having lunch with a friend of mine who's a very prominent personal injury lawyer. And he had just kind of litigated a personal injury case involving a child with special needs. And we were talking about, like, in his world, the child, the treater of the child or the treater of the plaintiff, that's the gold standard, right? But for reasons that are probably beyond the scope of today's presentation, treaters are reluctant to get involved in family court litigation, right? And so a lot of times you're probably well served to get somebody who's not the treater.
Like who? Like a nanny, like a teacher, or just give us some other examples if you're saying.
I would try to get a medical professional who's offering what the law calls a forensic opinion.
Got it. Okay.
Okay. This is really where consulting can kind of help if you've already gotten your lawyer. In fact, you've already gotten a settlement, right? Maybe. Because there are some times where you kind of default sort of generic provisions. Really what it comes down to is, in particular, if the child needs a special diet, right? And then, that's not going to be considered a medical expense a lot of the times under the standard language. And so there's that. And then the other thing is with respect to the duty to use a preferred provider within network, because sometimes children with special needs need medical providers that are not necessarily in the preferred provider network. And so there's that consideration from a drafting perspective as well.
Okay, so Mike, the bottom line is you're in the greater Houston area, your background is family law with a specialty in special needs. So are you available? So let's just say the people on here, they've already hired an attorney, but they want someone like you to consult their attorney on the special needs matters, such as, the higher amount of child support or child support going to a first party special needs trust or extended post age 18, all of these few matters that we've talked about. You're available to consult with their attorney. You're also available to be hired as a divorce attorney should somebody want to hire you. Is that correct?
Yes, that's correct, Allison.
Okay, perfect. So you guys can reach out to Mike directly. Again, you guys are going to get a copy of today's slides, Mary Ann's contact information as far as a coach. Mary Ann's got a lot of referrals and she's kind of learned a lot. Like, Mike was talking about some of these expert witnesses other things, people that'll come in. We get asked all the time. We, as a firm, we are way too busy to be going into court. So we choose not to do that at this time. Too many rescheduled court dates and things like that going on for us. So, but Mary Ann does have a whole handful of professionals that she knows are great expert witnesses and things like that. So she's a great person to reach out to as it relates to that. Guys, we have webinars all the time, every week. Our webinars are actually usually from 12 to 1 during the week. All of our webinars are surrounding special needs topics. So, we kind of danced around special needs trust. There's a such thing as a first party and a third party special needs trust. Those are going to be important tools for you on your journey. And so I invite you to join our upcoming webinars. We also have a Consolidated Planning Group YouTube channel. All of our webinars in the past live on that YouTube channel. You can subscribe for free, and you can kind of peruse the ones that might be for you on kind of where you're at and where you're going right now. But in this slide, you'll have a list of all of the upcoming webinars that we've got coming up. And this is just kind of a list. We have these in all of our webinars of things that should be on your special needs planning radar. And given the topic that we're having right now, you're probably thinking, oh my gosh, all I can do is think about what we're talking about right now. But there's a lot of things that do need to be on your radar. So when you're planning and you're thinking, you're investigating, keep these kind of in the back of your mind. Is probably more than what you can do to have them in the front of your mind right now, but just keep these out there. We work on a collaborative team at Consolidated Planning Group. We're always happy to meet with you. We offer free personalized consultations. So a lot of times on webinars like this, people don't want to air their dirty laundry, and that's okay. But we are happy definitely to consult with you, talk to you kind of about the plan and where you need to be. We can help you with those future care cost estimates, Social Security analysis, and of course we can make referrals for the other attorneys across the state, wherever you are in the state, that are specifically nuanced and special needs when it comes to those special needs trust and guardianship conversations as well. So guys, I think we are out of time for today. I got 1201 Kat with the Down Syndrome Association. As usual, it is wonderful to partner with you and your organization. Again, we had such a fun time. They just had their buddy walk at Constellation Field about a month ago, and it was really, really fun. You guys did a great job putting that on. So thanks everyone for being here and spending an hour with us on your Saturday. We hope you have a great weekend. And just remember, I just want to say again, because I know I myself, and I know Mary Ann did too, you are going to get through this. It does seem bad and it seems horrible and sometimes suffocating even, but there is light at the end of the tunnel. You are going to get through this. Treat this like a business, like Mary Ann said, and it'll go a little bit smoother. But I just wanted to give you another encouraging word to say that it does get better. So just know that for sure. So thanks everyone. Take care.